Let's discuss the enforcement of the Code of Ethics. It's important to note that while the primary focus of this course is on the actual Code of Ethics itself and not on the actual enforcement procedures, the Code does have an enforcement process. Because local associations have a duty to enforce the Code, and members might be involved in an ethics complaint someday, whether as a complainant, a respondent, a witness, or a panel member, it's important for members to understand and be familiar with how the Code is actually enforced. Each state and local association is responsible for enforcing the Code of Ethics. This includes providing mediation and conducting arbitration hearings. However, only realtors and realtor associates are obligated to abide by the Code, although all association members are encouraged to do so. Associations where membership is held or where MLS access is provided have jurisdiction to receive and resolve ethics complaints and arbitration requests filed against their members and the MLS participants. Remember, associations do not determine whether the law or real estate regulations have actually been violated. Such decisions reside with the regulatory bodies and courts. Often, difficulties between real estate professionals, whether realtors or not, result from misunderstanding, miscommunication, a lack of adequate and ongoing communication. Open, constructive discussion often resolves questions or differences and diminishes the need for any further action. When realtors are unable to settle disagreements between themselves, the local association can help. There are two options available: an informal dispute resolution through mediation or an Ombudsman program, or a formal dispute resolution by filing an ethics complaint or an arbitration request. The Ombudsman or mediation can resolve many disagreements and misunderstandings without the need for a formal process. Both Ombudsman and mediation programs use a neutral third party to help disputants work through their differences. However, when a formal process is needed, the local association can also help by hearing ethics and arbitration cases. Ethics complaints might be described as the conduct cases that deal with possible violations of the Code of Ethics. Arbitration cases might be described as the money cases in which disputed commissions between realtors, generally those involving two different firms, are resolved. Cases dealing with commission disputes between realtors in different firms are required to be arbitrated rather than litigated if any party requests the arbitration. An ombudsman is a voluntary process in ethics where the parties communicate with an ombudsman whose primary role is conciliation and communication. Ombudsmen do not determine whether ethics violations are occurred. Rather, they anticipate, identify, and help resolve misunderstanding and disagreements before they ripen into actual disputes and possible charges of unethical conduct. The Ombudsman program are also available if offered as a service to the local association of realtors, and that is voluntary on the part of the realtors and the consumers. Associations have considerable latitude in developing these criteria for an ombudsman, but they should be familiar with the Code of Ethics, the state real estate license law and regulations, and the current real estate practices. Realtors, staff members, and others may actually act as ombudsmen. Ombudsmen can also field and respond to inquiries and complaints about real estate transactions, ethical practices, and code enforcement issues. They can also receive and respond to questions and complaints about members, solicit responses, and actually meet with the two disputing parties. Parties may decline to actually use the ombudsman services. Ethics complaints resolved through an ombudsman are considered to be dismissed. Failure or refusal of a member to comply with the terms of a mutually agreed upon resolution permits the complaining party to file or refile an actual ethics complaint. The filing deadline is the date that when the matter was originally brought to the attention of the association. Ombudsmen can repair breakdowns in communication and develop acceptable resolutions between disputing parties. It's important to note also that associations of realtors has been required to provide mediation services to their members since January 1st of 2002. Mediation is the preferred dispute resolution tool of the realtor family. Voluntarily, unless this association at its discretion requires the realtor member to mediate per Article 17 of the Code of Ethics. This is a vehicle for creating a mutually acceptable resolution of disputes instead of having a decision imposed by actual hearing panel. They must be available to all realtors, and the local association mediation may also be offered to disputants before or after a grievance committee's review or arbitration requests. If offered before, then mediation must be offered again after the grievance committee determines an arbitrable matter exists. The process is simple. Disputing parties meet with the mediator appointed by the association. Parties explain their issues and positions and have the opportunity to ask each other questions. Mediators use a wide variety of techniques to move the parties toward a mutually acceptable resolution. If an agreement is reached, then the parties put the agreement into a signed document expressing the terms, and no arbitration hearing is held. This again being the preferred resolution tool by the Realtors Association. It must be available to all realtors, and it has to be offered before or after grievance committee's review. If it's offered prior, it must again be offered after the grievance committee determines matter is arbitrable and it forwards that on to a hearing. If a resolution is reached between parties, parties will each sign an agreement containing the terms of the settlement, and no arbitration meeting is actually held. The differences between mediation and arbitration are easy to see in this chart. Who can file a complaint? Any person, whether a member or not, having reason to believe that a member is guilty of any conduct subject to disciplinary action may file a complaint in writing in their own name and the professional standards administrator, dated and signed by the complainant, stating the facts on which it is based, and provided that the complaint is filed within 180 days after the facts constituting the matter complained or could have been known in the exercise of reasonable diligence, or within 180 days after the conclusion of the transaction or event, whichever is later. The grievance committee in ethics is very important. A grievance committee's review of the ethics complaint is not a hearing on the merits, but rather a preliminary hearing or review to determine if the complainant actually requires a hearing. A screening body comprised of members of the association. Their key question that they have to answer is, if the allegations in this complaint are taken as true on their face, is it possible a violation of the Code of Ethics occurred? The hearing panel then conducts a full due process hearing, including sworn testimony, counsel, witnesses, and evidence. It's usually comprised of members of an association's professional standards committee, and after the hearing, it goes into an executive session where it is decided whether or not there has been a violation of the Code of Ethics. Violations of the code must be supported by clear, strong, and convincing proof. Must also be determined and the discipline, if any, and imposed on the violator when the violation of the Code of Ethics has been found. A number of authorized disciplines and administrative processing fees can be set upon these found in the violation. The list includes the following: a letter of reprimand, a letter of warning, additional education, a fine not to exceed $15,000, probation, suspension of their license, expulsion from the membership from 1 to 3 years, suspension or termination of the MLS privileges, as well as administrative processing fees, if they're actually found in violation, not to exceed up to $500. The primary emphasis of discipline is for an ethics violation is education, to create a heightened awareness of and appreciation for the code. More serious or repeated violations might lead to more severe forms of discipline. Administrative processing fees, as a note, are not actual discipline. Fees should not be assessed on a case-by-case, but consistently, subject to the association's policy. Arbitration is defined by, and the arbitration of disputes is limited to, circumstances that fall within the parameters of Article 17. For example, the desire to collect damages for an automobile accident is not an arbitrable matter under the code just because two realtors were involved in an accident. Such a claim is not arising out of their actual relationships as realtors. Although less common, clients may also invoke mandatory arbitration against their realtor. In the event an arbitration award is not voluntarily paid, the award may be enforced through judicial action. Alternatively, associations may adapt procedures requiring that awards be deposited with and held by the association, pending the procedural review or legal challenges. The arbitration hearing panel conducts a full due process hearing, including sworn testimony, counsel, witnesses, and evidence, and it is comprised of the members of the association's professional standards committee. After the hearing is decided in an executive session who is entitled to an award, as demonstrated by a preponderance of the evidence. Any payment of awards may be followed by judicial enforcement when not paid by the non-prevailing party. Some associations actually require that when awards are not paid, an equivalent amount must be deposited within the association, pending review of the hearing process or during the pendency of any actual legal challenge.